All right, folks, buckle in. We've got a divorce turned property battle on our hands. And today's agenda, a contempt hearing. That means someone's accused of flat out ignoring a court order. This isn't just bickering over who gets the couch. This is potentially fine, jail, or both.
We will go on the record in the matter 22 FA45, in re the marriage of Timothy Ainley and Rachel Ainley. Appearances are we have both parties appearing in person without counsel. We're set here today in this matter for a contempt hearing. We were here previously on November 8th, 2024, in which we had a little bit of a hearing, and the parties were instructed to bring all evidence and information for the court to present here today. At the last hearing, Ms. Ainley informed the court that she was prepared to proceed with an accepted offer of the house for November 22nd, for tomorrow, to sell the house. And she needed Mr. Ainley to sign off on everything. And that's why the court scheduled the final hearing for today.
Quick legal note: in a contempt hearing, the burden of proof is on the accused. Translation: the judge's default is you messed up unless you can prove otherwise. Pressure's already on, Mr. Ainley.
Mr. Ainley, this is your contempt hearing, and so you have the burden of proof. I'm going to have both parties stand, raise your right hands, be sworn in.
You swear that the testimony you're about to provide to the court will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
All right, you may be seated. Mr. Ainley, at the previous hearing, you had indicated that there was a list of property that you stated that you had left at the marital residence, and that either was just left there and you had not yet received, or that Ms. Ainley had destroyed and that you wanted compensation for, and you were going to inform the court of that property and of the value that you were seeking. You may begin with your testimony.
Yes, ma'am. After the divorce was final, we came to an agreement that day on everything that was supposed to be surrendered to me, and she agreed on that. Well, being that there was a restraining order or no contact order in place, I had to come to court and get a court date set. It was signed by Commissioner Krupa for 2 days, on a Friday and on a Saturday and Sunday, to go retrieve my property. And the agreement was she was not to be on the property or on the property when she was supposed to have everything staged in the driveway with all my personal property. And I went out that day and...
Whoa, boyfriend at the property when she wasn't supposed to be there. That's like showing up too. A do not enter zone with a welcome banner, an anxiety attack or not. That presence could be a legal landmine for him.
Some of the items were out in the driveway, and I pulled in and started getting stuff. Here she comes. She had her boyfriend or whatever, fiance, whatever, doesn't matter. But she was there, and I automatically just had an anxiety attack. So I just got what was in the driveway, left, and therefore I couldn't go back the next day because, I mean, she was there, and that was, that was a violation, really. I mean, I couldn't go back. She was there. And to my knowledge, she refused to let me go to the property while she is not there and not have access to anything that was in the home, or my personal belongings, or my four-wheelers and everything like that, and my pontoon, my chainsaw. I had I got a list here of stuff that was, and I did retrieve a few things, and what was there was damaged and beyond repair. I mean, it was destroyed. The hole drilled through the block of the four-wheeler, the lawnmower. I mean, everything I had was just what I got. We did retrieve that was in the driveway was...
And here's the kicker. If the court order said anything left after these dates is abandoned, then we're talking serious stakes. Every missing tool, boat, part, or chainsaw could legally be considered gone for good.
Totally destroyed.
So at the time of the divorce with Commissioner Krupa, and that was Well, actually, the divorce was with me on March 6th. There was a list of property that you were to retrieve. Is that correct?
Yes, ma'am. I'm not real sure of the exact date. Commissioner Krupa put that order into place. My attorney at the time was Adam Benson.
Oh, that was September 28th, 2023, in which you had the hearing with Commissioner Krupa to go retrieve your property from the divorce.
Yes, ma'am.
All right. And it says, though, that anything not picked up after those two dates is considered abandoned.
Exactly. I could not go in there. She was there, and it stated in the order from Commissioner Krupa that she was not supposed to be there. She was. I mean, that was just a setup for me to go back to jail again for violating an order of protection.
At the hearing on September 28th, 2023, did you provide a list of that property to the commissioner or to the court of what you wanted to retrieve?
That list was already included with our divorce hearing. All of my personal tools, all of my personal property, the furniture in the basement.
Yes, that was Exhibit 1, the personal property list. And yes, I have that. Okay. And we're talking about the pontoon, the tools, the generator, the Ford Ranger, the chainsaws, all personal belongings. That list, is that what you're referring to?
Yes, ma'am.
Okay. You may proceed.
I have a list here which doesn't scratch the surface, but I have a list here of everything that I have not retrieved and that was either damaged or not damaged, but destroyed. I never got anything back that was damaged other than the toolbox, the Performix toolbox, and that had sat out in the pontoon along with whatever else was in there for a couple winters, and it wasn't even salvageable, excuse me.
First, Ms. Hess, formerly known as Ms. Ainley. Were you at the property when Mr. Ainley went to retrieve his?
I was in the house, yes.
Why were you at the property?
I had nowhere to go, and I had to get his stuff out.
You were specifically told at the hearing with Commissioner Krupa on September 28th, 2023, that you were not to be anywhere on that physical property.
I didn't have a choice.
You did have a choice because Commissioner Krupa said not to be on that physical property, not to be on that residence at all.
I didn't have no idea what time he was supposed to even be coming. Was I supposed to stay gone all day?
You did know, and I can tell you right now you did know because it says pickup times September 30th, 2023 between 2 p.m. and 4 p.m. and October 1st.
The judge is calling out the timeline receipts here. This is where specific dates become courtroom gold. You can't just say I didn't know. When the court order has your pickup time printed in black and white?
2023 between 2 p.m. and 4 p.m. So you knew exactly when he was going to be there. Exactly.
Leaving his stuff out there. He's already saying it was damaged.
You just lied to the court. You just lied to the court.
No, I did not know.
You did know. You did know. That's
he
physically.
didn't show up. No, he did not show up when he was supposed to. There was time set in June for him to come. He didn't show. I didn't know if he was going to show or not. I wasn't going to take a chance of leaving his stuff sitting out there.
Mr. Ainley.
Your Honor, if it need be, I've got two witnesses that came with me with two trailers to load my personal property up. Her and her ex-fiance was out there. Her middle son, Dylan, was out there. They were all out there. She walked up and down the driveway following me, trying to talk to me. So that's all I got to say. She was there. She knew the date. She knew the time. I was there about 10 minutes after I think it was it. I really can't recall the exact time on the clock.
I believe she knew the date.
Ouch, I do not find her credible at all. That's judicial speak, for your testimony is sinking fast. Once a judge stamps you as not credible, good luck getting them to believe you on anything else today.
believe she knew at the time. She just lied to the court.
Yes,
I do
ma'am.
not find her credible at all.
Yes, ma'am.
Continue.
All right, this is a list of my personal property. All my clothing, all my suits, my dress slacks, everything from hunting, winter, everything was burned in the backyard. It was told, my children told me that.
You can't tell me what your children have told you.
Journey, my 9-year-old, and my 12-year-old said that.
Can't tell me what they've told you.
Okay, so what are you asking then?
I'm asking what property you have not received and what you're asking as reimbursement for that property.
I don't have it added up, but I've got everything itemized with the replacement costs. They just have to be added up. I've got this.
To know where you've come up with these prices.
Well, for one thing, the Performex toolbox, I bought that at Menards about probably 5 years ago 6 years ago when we bought the property. And I just looked up the replacement costs on it. No taxes included or nothing. And I mean, this is the bare minimum cost it would cost to replace my equipment, my tools, my personal belongings. And I even went on a low end of what it would, actually cost.
Can you hear him? Is he mumbling? You need to speak
Yes,
in the
ma'am.
microphone, and you need to speak clearly because the court reporter needs to take everything down. If I can't hear, that means she can't hear.
Yes, ma'am. I went through and researched everything that the replacement cost on every piece of equipment and all of the tools itemized of what it would cost to replace them. And I went on the low side of on the price that it would cost to replace my tools and my.
Notice how he's framing this as bare minimum replacement cost. Smart move rhetorically, makes him sound reasonable, even if the total bill might make your wallet cry.
Personal belongings. And this is a bare minimum. I'm not asking for anything more other than so I can replace my equipment to get my contracting business back off the ground. And I mean, without these tools, I walked out of that house when we divorced. I walked out of there with a torn up clothes basket with 2 pair of shorts, 3 pair of underwear, and a couple pair of socks. That's all I ever got out of the whole divorce. And it's just, and when I told my stuff was burned in the backyard, it's pretty kind of heartbreaking because I had really nice clothes and I dressed nice. I mean, everything from the Ranger truck. I got pictures of the Ranger truck that was destroyed, and supposedly my clothes that were supposed to be in the back of it that sat out there for a couple winters. Not one piece of clothing was in the back of that truck that belonged to me. There was one shoe, a pair of my Docker dress shoes, one shoe, and the rest of it looked like her clothes she's just thrown out in the back of my truck, and it sat out there. It was just molded and saturated. I could tell it sat out in the back of that abandoned truck for a long time.
You're telling me a lot of stuff that's not relevant and that you don't have personal knowledge of. I need to know what you know and how you have personal knowledge of it. And I need to see evidence and proof.
I have pictures of everything that was in the truck and the damage to the truck. I have the pictures of the truck and the stuff that she returned that was in the back of the truck when I had it towed to my house. I basically had a garbage dumpster towed to my place.
All right, so the court is taking judicial notice of Exhibit 1, which is document 36 in case number 22FA45. That is the list of your personal property. And I'm guessing you're talking about your Ford Ranger. If you would like the court to have any exhibits, and if you're talking about those pictures of the truck and any list of items that you're asking the court to
It's lesson 101. In civil court, if it's not documented, it basically doesn't exist. Pictures, receipts, copies for everyone. Miss that step, and your strongest claim evaporates.
Reimburse you for, which you still need to provide testimony as to those items and as to the amounts that you're seeking. I need them to be marked as evidence and provided not only to me, because I informed you I needed a copy, Ms. Ainley needed a copy, and you needed a copy, so you needed to provide 3 copies.
Okay, I wasn't clearly aware of that. That was my mistake. I do have a 1 copier. I can get copies made of the my actual personal belongings.
Your Honor, may I say something?
Not your turn.
If I could have a few minutes, I can take the staple out and take them down somewhere and have copies made of
Go
everything.
pay for copies at the clerk's office,
Yes, ma'am.
and you can pay for colored copies of your photos, but you need to have a copy for you, a copy for Ms. Hess Ainley, and a copy for me.
Yes, ma'am.
But before we take a break and adjourn, Ms. Ainley, what would you like to say?
All of his belongings that he did leave are at the house. I haven't touched anything.
But I
His
don't,
generator,
but
his,
here's the thing. Again, I fully instructed both of you. And I'm gonna guess you don't have pictures or documentation of their condition.
no.
And
It's
so
the same
I'm
way
gonna
he
take
left it.
testimony from both of you. And so far,
This judge is playing no games. Both sides need proof, not just stories. Right now, credibility is the currency in this courtroom, and only one party seems to have much left in the bank.
I found you not credible. So we're going to briefly adjourn, and you can go get copies of all of those documents so that we can all have copies. And if you have other documents that you're going to want to use as exhibits, you're going to need to make sure that you make them right now. And if you have a copy of some document that you're going to need as an exhibit, you need to go get copies made as well, so that I have one, Mr. Ainley has one, and you have one. Because the court needs one and each party needs a copy, okay?
Yes, ma'am.
All right, then we are briefly adjourned. You need copies?
Yes, ma'am.
Can you go get one set marked, please?
Are they each gonna be separate, like you're gonna present each one separately, or all the same thing? Is it all gonna be like one?
I would say the pictures as one.
Whatever the ones that are the same, I think I've got to have them stapled together.
Oh, so this is the original, which you can have it. Oh.
I've got copies of myself. Same thing.
Oh, okay, so these are different?
Yes, ma'am.
Oh, okay.
6 pictures in one page. I can't talk to her.
Is she supposed to get a copy?
Yes, just give her all the copies. All right, back on the record, same appearances as previously noted. Mr. Ainley, you have now went and got copies of your exhibits, one for you, one for Ms. Ainley Hess, and one for the court. You may proceed with your testimony.
Yes, ma'am. The replacement costs and the list of personal items are all stapled together there. It goes from the tools and equipment. It goes, it's continued there. And I've got a sheet with the heading clothing and footwear. And I've got furniture in the basement that was ordered to me. And then the last sheet is my sporting equipment.
All right, well, you have to provide testimony so I can understand what it is that you're saying that you didn't receive, and then where you, what cost you're looking for, and where you came up with this value.
Yes, ma'am. Starting on page 1 with tools and equipment. I had a Performax
You
3P.
have to, you don't have to go exactly line for line and tell me, but because I'm gonna guess there's like 1,000 items.
No, ma'am. This is the personal property that I had for my business, for my sporting, for my hunting, fishing, camping, my dress clothes, my everyday wear clothes, my winter clothes, my winter boots, all of anything and everything that I needed to live an everyday life was gone. Everything on this list, I never received this, except I did receive the pontoon boat. The 18-foot.
The pontoon boat, okay.
Yes, ma'am.
And what was the value of the pontoon boat?
About $4,500. That's what I paid for it about 6 years ago. It's nothing real fancy, but it was nice for the family.
So you received the pontoon boat, so you're not asking for pontoon boat back.
I sold the pontoon boats. It had holes drilled all in the pontoons and the motor was busted all up on it. So I sold that for $1,200.
Okay.
The 22-foot camping trailer.
With regards to your, let's start with your tools and your
Here's where the math gets messy. He's got values for some categories, none for others, and no grand total. In court, that's like showing up to a bake-off with half a pie and saying,
equipment.
Yes, ma'am.
Now, you have a lot of tools and equipment here. How do you know that all of these tools and equipment were at the property?
Because I left not one piece, I left the property with nothing but the clothes on my back, basically.
And where did you receive all of the values for these each individual pieces of tools?
I purchased them myself personally. I purchased every piece of equipment, every tool that's on this list.
And how did you arrive at the value that you're asking for?
It is replacement cost to go purchase the same exact item that's on the list.
How did you arrive at that value?
Oh, I Googled it, looked it up online.
But where did you get the value? Google that just doesn't come up with.
Menards. You mean stores? Menards. I got some of it at Menards. I got some of it on just different sites that sell that product and that brand name product.
I don't see a total for your tools and equipment.
No, ma'am, I haven't totaled that up because I didn't really know exactly what I would be awarded, so I thought I would let the courts do that. Here it is. It's on the last page.
Let the courts do that?
No, ma'am. Let me rephrase that. I do have it done. It's on the last page.
So the total of all of the items that you're asking for is $8,800?
No, ma'am. That is just for my sporting equipment.
Then where's the total of the tools and the equipment?
That is, I never totaled that up because I did not know exactly what I would be entitled to. I can add that up.
But I'm not going to take the time to add all of this up.
This is all new for me, Your Honor.
So clothing and footwear?
Yes, ma'am. Clothing and footwear's $45.50.
And where are you arriving at this number? Because it's just a guess and I don't have any idea. We're not talking about like guess or We're not talking about Michael Kors, or we're not talking about, you know, some other high-end type of clothing. I don't have anything identified, just shoes and boots, coats and jackets.
That was just a low ball idea of.
The judge is making an important point even for donated clothes. The IRS expects an itemized list. And here, we're not talking charity, we're talking compensation. That means every sock, every jacket, every fishing pole needs a price.
Even just skimming the surface of the stuff I had. Some of the stuff I looked up, like Docker khaki casual or khaki dress slacks. I just looked up pairs and I thought, well, I had probably 5 or 6 pair of those. I just a rough estimate, you know.
I don't even have casual and dress pants. I don't even have 5 dress pants, 6 shirts. You even have to itemize when you donate to Goodwill for tax purposes, and I don't even have an itemization of that for this purpose.
I wasn't aware that I needed to itemize it.
You do.
I mean, as far as clothing goes.
You have to be specific, because I can't just say, okay, well, I'm going to guess there's $500 worth of clothes or $4,550 worth of clothes that she destroyed. It needs to be specific. It doesn't need to be down to, it was 6 pairs of Dockers that were in great condition, 4 pairs of Levi's, you know, 7 Nike shoes and things like that. But I need to have an idea, because even again, for tax purposes, you need to identify when you donate to Goodwill, or you donate to Salvation Army, or you donate to anything like that. You have to have a general idea of 7 sweaters, 6 pairs of shoes, 1 table.
I understand that now. I wouldn't even begin to even start to know how many pair of Dockers I had, and those are $65, $70 a pair. I know I had 5 or 6 pairs of those, and nice dress shirts, tie. I mean, I have no way to even begin to make an itemized list of my clothing. I mean, I had a huge closet full of clothing. I mean, it's not like I go through on a yearly basis and inventory my clothing. I know it's a mistake on my part, but
you understand that otherwise you're asking the court to speculate.
Okay, I understand that now that you put it that way. Yes, ma'am.
Furniture in the basement. I have a Samsung TV, surround sound for TV, a couch and a love seat, but I don't have exactly what type it is. A coffee table, end tables, an antique dresser, deer mount, walleye mount, antique reel collection, but there's no dollar amount on those 3.
I have no way of even valuing my deer mount. To me, it's priceless. My walleye mount, I don't know how to value that. And with the antique reel collection, I have no idea I'm not asking anything for the deer mount.
Ending on a tricky note. Sentimental items like deer mounts and antique reels may be priceless to him, but in court, priceless often equals $0. Emotional value doesn't pay in legal currency.
The walleye mount or the antique reel collection. I'm just adding that onto the list so it is known what I have got missing.